Now, this is a very sad tale, but it raises some very important, interesting and indeed topical issues. One issue I'm going to have is how to discuss this without annoying the YouTube algorithm, so please forgive me for some of the euphemisms and circulations, however that word is. But basically it starts like this. There was a lady who had a terminal illness. It could not be treated. And basically she was in a lot of pain, she was very, very unhappy, and she just decided that perhaps the time came to end it all. So she discussed this with her family, and her family, they rallied around her. They said, look, we love you, we'll do everything we can to help you. But she was quite adamant. She said, I appreciate all this, but the fact is, I just can't go on like this anymore. So her husband assisted her in travelling to Switzerland to one of those clinics that specialises in this sort of thing. And her children also accompanied her because they wanted to be with her at the end. And that was all done. Upon the return to the UK, the husband reported himself to the police, explained exactly what had happened, gave them a full account, and said, look, I appreciate I may have committed an offence here. The police, however, they got back and said there was nothing to report. As far as we're concerned, no offence has been committed. All well and good, you may say. However, there's something called the Forfeiture Act, 1982. And what that says is that if somebody is involved in the unaliving of a person, and they would be normally a beneficiary to that person's estate, that estate is forfeited. Because, I've discussed this before, that, you cannot benefit from your own criminal conduct, all the Son of Sam stuff. So, what happens here? Well, there had to be a court case. And again, it's fair to say that all parties concerned, they realise the sensitivity of this, and they all work together to make this as painless as possible, ironically. So they went in front of a judge called a master. It was actually the senior master, to try and sort of, work out, first of all, some of the procedural issues. Who brought the claim and who did they bring the claim against? Well, the claim was brought on behalf of the husband because he was seeking to set aside the provisions of the Forfeiture Act. And in the Forfeiture Act, there is a provision that says that a judge can depart wholly or partly from the provisions of the Forfeiture Act if, in all the circumstances, it's in the interests of justice to do so. Now, the defendants in the action were his children because if he was to forfeit his legacy, the benefits coming to him, then it passes down under the normal intestacy laws to who's next. Now, in this particular case, the mother, she had made a will that sort of left everything pretty much to her husband, but then some sort of minor gifts, including pecuniary gifts to other family members and indeed friends. And the master said, well, what's the position here with the actual defendants? Because the defendants made it very clear they fully supported the claim and the application. They wanted their dad to inherit the mother's estate. The master said, bear in mind they also travelled to Switzerland. Are they themselves, do they fall foul? Because it's an offence to assist in unaliving somebody. However, it's an offence that can only be prosecuted with the consent of the Director of Public Prosecutions. It's not one you can do a private prosecution on. Well, you could, but you'd have to get the consent of the DPP. And in this case, like I say, the police had said they didn't even see an offence had been committed, so it wasn't even referred to the CPS. However, the court held that, bear in mind, all they had done is go across to sort of, be there at the end. And, it was clear that they had actively tried to discourage her. They said, well, no, we will accept that there's no danger of them forfeiting. And in fact, they should be the people that this all goes to. I mean, they contacted everybody. They contacted like the HMRC because there would be tax implications depending on it when. You might even get into actually the intestacy thing. If they just said none of the named beneficiaries are eligible to recover in this, then it would have just gone what we call bona vacantia, property that doesn't belong to anybody, and it goes to the Crown. So obviously these are all the procedural issues. There's a test, though, when it comes to prosecution. And they looked at this, even though they'd agreed there wasn't going to be a prosecution, they thought the test was quite relevant to whether to engage this section of the Forfeiture Act that says you can actually go behind it. And it provides a number of factors. It's first of all, it's 16 factors in favour of prosecuting, because to bring a prosecution, there's a two-part test. There must be a realistic prospect of conviction, and it must be in the public interest to bring the prosecution. And in this case, obviously, there would be a realistic prospect of prosecution, because arguably, he admitted everything. I mean, the standard is very low. It's just any act that may assist or encourage somebody to do this. So the test is quite low, but that's why you have the discretion of the DPP to say, in all the circumstances, I don't think this prosecution should go ahead. And that's an entirely different factor, actually. That's something I might cover at some stage, is there is a bit of among the legal profession, we're not always very happy about this idea of prosecutorial discretion, because the idea is the law should be clear. It should be, here's what you're allowed to do, here's what you're not allowed to do. And should it really be up to the whim of a government minister as to whether, or indeed the CPS, as to whether you have actually, you should be proceeded against? It's all very arbitrary there. But they looked at the factors. And the judge said none of the factors that make it in the public interest to prosecute are present. I mean, that's stuff like coercion, where people weren't genuinely consenting, where it's children who couldn't consent, all that sort of thing. But they said, however, there are a number of factors that are listed that mitigate against a prosecution in the public interest, and they all are present. And they're things like, the person had made it very, very clear over a long period of time that they wanted to do this, that they were actually of sound mind and body, that there was no prospect of a cure. One factor actually is that the people have actually tried to discourage them. Obviously that's just a factor that they take into account, although I'm not sure about that, because somebody could have very strong held beliefs and say, yeah, I fully support this decision. So should you be penalised for actually supporting a loved one and holding those views? But like I say, it's not determinative, it's just a factor they take into account. So here the judge held and said, looking at all these factors, it is very clear that this was an act of compassion and mercy done very, very reluctantly. And the only reason that he went along is because she was physically incapable of actually arranging this and carrying this out herself. She needed the assistance, and very reluctantly the husband agreed to do that with the full support of everybody else in the family. And so as a result, the judge said, I'm going to disapply the Forfeiture Act completely. Yes, you can inherit the estate. But I just thought it's very topical, because we've got the assisted unaliving bill going through Parliament at the moment, and there's lots of discussion about this. So I'd be very interested to hear your comments as to, first of all, specifically this actual individual case. Do you think the judge made the right decision? Do you think the judge made the wrong decision? But also what you might think of it generally, because this might be a topic for a follow-up video. So there you go. As always, hope you found that vaguely interesting, vaguely informative. I actually find it sort of quite heartening that in the end, sad as this was, somebody was allowed to go out on their own terms and with the assistance and support of their loving family, who stayed there to attend, to support her at the end. I mean, but that's just my personal opinion. I feel very, very, you're very, very welcome to disagree with that in strident terms if you feel it's appropriate.